Hello, my name is Ryan Holland and this is my current trends case brief presentation exploring the case R v. Dyckman and Salmon, 2013 ONSC 687. In this presentation we will look at the case citation, the facts, the issues, the decision, the rationale, analysis, and finally a survey question. The citation. The citation for this case is R v. Dyckman and Salmon, 2013 ONSC 687. The facts. This case deals with the issues of fraud and whether obtaining private records through a subpoena is a violation of Section 8 of the Canadian Charter of Rights and Freedoms. Therefore, the relevant law that applies to this case is outlined in Section 8 of the Canadian Charter of Rights and Freedoms. Section 8 of the Charter states that, quote, everyone has the right to be secure against unreasonable search or seizure, end quote. What the defense argued. The defense argued that any materials obtained by way of subpoena violate their right under Section 8 of the Charter and should therefore be excluded under Section 24(2). They believe that whenever the Crown wishes to seize, examine, or copy documents in the possession of a lawyer who claims privilege over those documents, the law requires the Crown to seize the materials pursuant to a search warrant issued in accordance with the guidelines set down in R v. Laval, 2002 SCC 61. What the Crown argued. The Crown believed that Section 8 of the Charter was not even engaged in this case because the subpoena process is neither a search nor a seizure. Also, even if the documents were obtained by a search or seizure, the Crown argued that the subpoena process is a valid method of obtaining private records. Facts continued. Deborah Dyckman and George Salmon were charged with fraud after they allegedly operated a number of businesses that stole millions of dollars from the federal government. According to the Crown, the accused used a legitimate business providing payroll services to various employers. However, instead of forwarding amounts collected to the Canadian Revenue Agency, the CRA, they kept the money for their own use. During the investigation that led to these charges, various representatives of the CRA met with Mr. Peter Silverberg. Mr. Silverberg was the lawyer that the accused hired to deal with legal issues involving the variety of businesses the accused owned. Prior to the preliminary hearings, the Crown served a subpoena ducis tectum upon Mr. Silverberg. Mr. Silverberg complied with the subpoena and attended the preliminary hearing with all of the company's private documents, in which he claimed solicitor-client privilege over them. The applicants objected to the documents being produced to the Crown or the court on the basis of a subpoena and argued that the production of the documents would violate their rights under Section 8 of the Charter. The Crown asserted that the documents were admissible because either A. they were not privileged, or B. any documents that were in fact privileged were admissible pursuant to the crime-fraud exemption. In the preliminary hearing, Justice Allen determined that he had no jurisdiction to rule on an alleged Section 8 violation at a preliminary hearing. When the case went to the Superior Court of Justice, Justice Corbett was the trial judge. Justice Corbett ruled that the Crown was within its rights to obtain the documents by way of subpoena. After recusing himself due to a conflict of interest, Justice Baltman, the next trial judge, decided to rehear the arguments. Justice Baltman also decided that the Crown was within its rights to obtain the documents by way of subpoena. The issues. There are two issues associated in this case. 1. Was there a search or seizure within the meaning of Section 8 of the Charter? And 2. Is a subpoena a valid method of obtaining private records? The decision. The decision was that the applicant's motion cannot succeed on 2 points. Firstly, the documents in issue were not obtained pursuant to a search or seizure, and secondly, the subpoena process is a valid method of obtaining private records. The rationale. In order for Section 8 to even apply, there must first be a search or seizure per the ruling in R v. Jarvis, 2002, SCJ, number 76, paragraph 69. Assuming a search or a seizure has occurred, it must then be determined whether either of those actions was unreasonable as Section 8 protects only a reasonable expectation of privacy, per the ruling in Hunter et al. V. Southam Inc., 1984, SCJ number 36. Justice Boltman stated in his opinion, neither a search nor a seizure occurred because after Mr. Silverberg announced that he was claiming privilege over the documents, no one in the Crown's office or on behalf of the prosecution got access to them in any fashion. It is therefore clear there was no search. Justice Boltman also determined there was no seizure of the documents because in this case nobody took anything without prior consent. Mr. Silverberg was ordered to bring his files to court and did so, but they remained in his custody until the parties agreed on how they should be handled further. Given the conclusion that neither a search nor a seizure occurred here, there is no basis to consider whether a breach of Section 8 has occurred. Applicants maintain that the Crown cannot obtain documents from a solicitor's office by way of a subpoena. They say the Crown must use a search warrant based on the decision in Lavelle and upon the decision of Justice Trotter in RVVI 2008 OJ number 2856 open bracket SC close bracket. Justice Boltman, however, did not agree with the ruling that requires the Crown to use a search warrant. He believed the decision sets out guidelines for how law office searches must be conducted and concluded that Section 488.1 is unconstitutional because its provisions allowed for excessive intrusion into the realm of solicitor-client privilege. Justice Boltman also stated that Lavelle prescribes that before a search warrant is granted on a law office, the authorities should consider other alternatives. This provision suggests that a search warrant is not the only legitimate means of obtaining privileged material. Presumably, a reasonable alternative is one that is just as effective but less intrusive, which is precisely the advantage of a subpoena. Therefore, in conclusion, Justice Boltman found that a subpoena is a valid method of obtaining documents from a lawyer's office. The analysis. I personally agree with the ruling that Justice Boltman came to. In no way were the documents searched or seized by the Crown, and therefore there was no violation of Section 8 of the Charter. I also believe that a subpoena is a valid way of obtaining personal documents, for the reasons stated by Justice Boltman. In the end, Deborah Dykeman was sentenced 4 years in jail and was fined $1,285,930 for tax fraud, and George Salmon was sentenced to 2 years in jail and fined $397,758 for tax fraud. Survey question. Based on the nature of the case, fraud in this example, do you think the accused were hindered in any way by not openly disclosing their personal documents? Would it have been better for their sake to disclose their personal documents and financial documents for the duration of the trial?